How does a beneficiary in New Jersey avoid paying any taxes after receiving the estate? This is an interesting question with a multiple part answer. Before we get there, I'd like you to think about a close friend who's struggling with a what if scenario that creeped into their lives, but they were better prepared because you shared our videos. We would appreciate it, as will your friend. I'm 𝗣𝘆𝗶 H𝗶 an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we can help some folks along the way. Now, it's very important. You have to define what type of taxes we're talking about. Since this was an open-ended question relative to tax, I am going to address all of them that come to mind when it comes to an estate. First off, an estate tax. That is typically payable from estate monies. Now, New Jersey itself does not currently have an estate tax. They did away with it several years back. So this would only apply if we were talking about federal tax, which has a current very high exemption. But again, if there were an estate tax, it would be paid from the estate monies prior to distribution to the beneficiaries. So it wouldn't come after the receipt. New Jersey does have an inheritance tax, which is based on the relationship of the beneficiary to the decedent. Okay. Certain relationships are exempt, such as children, grandchildren, etc., spouses, but others are not. Again, if there is a tax payable based on your relationship in New Jersey and there's an inheritance tax, it is payable again from the estate prior to distribution to the beneficiaries. Okay, so it's not paid after you receive it. Now, the other two types of common taxes that are payable when an administration following someone's passing, what taxes are possible are ordinary income taxes and capital gains, right? These could be reportable in several places. Sometimes there's income that still needs to be reported under the decedent's final personal income tax return themselves, on what's called a fiduciary income tax return for the estate or trust that accrues after the passing and before the distribution to the beneficiaries. And then eventually there could be taxes payable at the beneficiary level and perhaps prior to the distribution of all of the assets. And I'll explain that in just a second. So, two parts again, ordinary income and capital gains. Now, whenever they're accruing, they have to be paid somewhere, right? There's no avoiding the income tax. It's just a matter of who pays it and where. Now, once the decedent's final personal tax returns are paid up through their date of death, it is often best to pass through the income to the beneficiaries directly, because the rates under the fiduciary return, right, the trust return or estate return, go much higher, much faster. Whereas on our personal level, it takes some levels of income to get you to the highest brackets. So it is typically beneficial to do so. And I'm not going to get into some of the nuances as to when and how those flow through income requirements can happen, but there are some nuances that you should collaborate with the accountant, and if your attorney is knowledgeable in tax, to determine what the best approach is. Now, on the capital gain side, right, if any assets grew in value from the date of death forward, there will be a gain at the time of the sale. And this, again, has to be paid somewhere. And even though capital gains are typically at a lower bracket when it comes to the tax rate, it still is preferential in most circumstances, not all, to pass that through to the beneficiaries. Keeping in mind that the beneficiaries may need to have a partial distribution to cover the tax consequence, which is only logical. I hope that you've learned something new here today that you choose to share. And as always, please take care.